Well, my career journey started in somewhat of an unusual way, because I started off really thinking about a typical good career. So I actually started my career in accountancy. So I joined Price Waterhouse, and that was before they had merged. And but very quickly realized, because I had got a law degree, I had quickly realized that it really wasn't for me. But at that point, I was still somewhat lost. I didn't really know where I wanted to go. But when I decided I would go into law, and I went to the University of Law, it was almost immediate. The feeling was visceral that I knew I wanted to do employment law, so much so that I actually started reading it up prior to starting. And I do question, I've often thought about what it was that drew me to it. And I think one of the main reasons was that, unlike corporate law with the big numbers or tax, where you've got no human element, and also unlike criminal and family, where you sort of have too much human element. I loved the balance between the fact that you would have a business area of law, but you also had some ethics, you also had some right and wrong. And that really appealed to me, because I felt, and I think at that point I hadn't really understood who I was or who I was becoming. But clearly there was the glimmer of the fact that actually I really do have a sense of what I think is really, what really matters. And the idea of doing something, I mean, when you start your life in audit, it probably is probably not so difficult to imagine that you realize how wooden and flat a life or a career can be. But it was a slow evolution. And I think now I realize, because one thing that's a bit quirky about me is I'm also a novelist. And I always thought that was a completely different area of my life. But increasingly, I've discovered that very often my novels fight for women's rights. Not overtly, but the message underlying it is that not to oppress people, and some of the storylines, although they are a bit gruesome at times, they do send out that kind of theme. And it's only afterwards I realized that I must have something deep inside me. And now, increasingly, in every day of my life, I see people who have suffered so badly because of the way they've been treated, or that they want to flag an act of discrimination, and they feel that their whole career will be destroyed. So I have such a connection and such total belief in your project, the Culture Shifters, because it's, to me, it's almost the missing piece to try and bridge that gap. And I do feel quite strongly that that when people go through these devastating experiences, I've always felt that where I can help, sort of not just legally, because you could be a wooden robot and come out with what needs to be done, look at strategy, but I also say, it may, first of all, you are brilliant. Do not let this experience make you think that you are less than or not good enough, because clearly, and 90% of times, there is politics, bad actors, and all those sorts of things going on. But I also try to encourage them to realize that everything will be much better given some space and distance. I often get people contacting me saying, "You are so right, a few weeks on and I can't even believe I stayed in that scenario. I am so glad I left," and those sorts of things. So it comes from a sort of realization of who you are, in a way. I mean, I couldn't be the sort of person that deals with crime or divorces. It would be so difficult. But on the other hand, I would die a living death if I did leases all day. And so it was very much who I was. And I realized quickly that this is something amazing, the whole workplace setup. And I do tell myself, and this is important, that there are situations where I think this is just so awful. I mean, a typical one is where someone has been subjected to sexual harassment, or someone has been given a package to leave because they've just had a baby or they've become pregnant. And we know the storyline behind the scenes. But a lot of times people will take the view that, I will take the deal. I will just I haven't got the fight in me. And it's sad because the law isn't really working, but people do get a degree of compensation, and where we can, we fight for them, and where they're willing to, we do achieve amazing outcomes. But my point, I suppose, underlying all of this is we still have a brilliant framework here. And I sometimes think, well, had you been in some other country, which I probably shouldn't name, but there's a number of them, and you did something wrong, you'd be out without even, or you didn't do anything wrong, you'd be, just on a whim, you could be out of a job, and you've got all of that hanging over you, and there's no concept of rights. So I still do appreciate that we have a structure. But my main thing I always say is that justice is not the same as law. I know that sounds completely counterintuitive, but certainly in employment law and workplace law, justice and the law are not equal, and we frequently have to tell people that this is actually a very good solution for you. It isn't justice, it isn't right, it isn't what should have happened, but it is not a bad option when you consider all of the factors, some of which we'll probably touch, like the state of the courts these days and the changing laws. I think that something that is really important is that there is underlying in my role, in my daily life, this permanent frustration that people who are wronged don't always have a remedy that's going to be a solution. So I do really feel that the idea of change at grassroots levels, with the way culture shift is endeavoring to encourage reporting and close the gap, is actually the missing link, and I think that's what we need. So my work focuses on employment law across the board. So I act for companies and individuals. It tends to be executives, but not exclusively. And my work is so fascinating. And I have to say I'm incredibly grateful for this, because there is no sense of being tired, because you get the most interesting personalities, the most incredible storylines, things that you possibly wouldn't even believe. And I have to be very cautious over the dinner parties to make sure everything is anonymized, because it's just so interesting. When you look at some of the horrible cases outside of employment law, like the Pellicots and the abuse scenarios, and you always have to remember that the workplace is a microcosm of the larger world, and so you do sometimes see the most horrendous personalities and characters, and people need to know that they can speak up and that they won't the hope is they won't be subjected to a detriment or job loss. I remember seeing such a fantastically big shift after the Me Too movement, because I'd spent so many years trying to encourage corporations to not just pay off, but to try and resolve, address, and put right. But there is that gap where you are doing a particular role and a particular job, and short of training, you can't go in and sort of figure out what's wrong with the culture, what's wrong with the mindset of this organization. And there are well-known poisonous organizations out there still that don't seem to have addressed this. And after the Me Too movement, or during it, I noticed such an increase in resolve, sort of willingness for key stakeholders, key HR directors and senior managers to actually take a stand, even if the person concerned was a founding director or someone who was very influential and important in the corporation. And that was tremendous. But I did realize even then the work had only just begun, because I remember a particular case involving a bank where this founding director was known to be so discriminatory and harassed people, and people would just leave. And finally, the HR director I was dealing with said, we're taking a stand. We're inviting him to a disciplinary investigation. We are bringing him. And, it was a real moment of power, because he was totally stunned that he would be called into a meeting. And even the individual that had made the allegation was more willing to speak up. And when the whole process started, I was so delighted, because change has to happen at that level. It has to happen where the real power sits. And And then the woman I was dealing with, the HR director, went to leave. She left on maternity leave. And then a new person came in. And what do you know? Settlement agreement all brushed under the carpet, all gone. So I thought, this is just the start line. It's just the point at which we start. And my hope, my absolute dream, without a doubt, is that we will see workplaces where this sort of ugliness is wiped out. I mean, I don't think people in power or people that are independently wealthy appreciate just how central your job is to you. It determines everything aside from food on the table. We've got a mortgage culture. We've got kids and families that need looking after. And so if there isn't a degree of fairness and good treatment, it has ramifications so far beyond just a workplace, an irksome workplace situation. And I think people should be aware of that. And I also think one thing that is increasingly visible to me in my practice is the impact on mental health. We're seeing that a massive increase, and I'm not even sure that it wasn't always there, but it's now been revealed and exposed as a thing. But some people, they suffer so badly because of what they're subjected to in an environment, and it's fundamentally unfair. So it has ramifications even beyond just practical living. It can impact people's health, even to the point where a person I'm dealing with at the moment had suicidal ideation, and that I've seen only a few times in my career, where people are subjected to something, and because of their state of their mental health, it has such a fundamentally dangerous impact on them, and you will never know if that's the kind of person that you're necessarily dealing with as an HR manager. So great care has to be taken. The future of employment law is going to experience a sea change. It's going to be so fundamental and so massive. Now, in my decades, because I've been around a while, I've seen changes happen, and I saw shifts when there were fees introduced to lodge claims employment tribunal, changes in the qualifying period, and all of these things. And yes, they had an impact, but I don't think, honestly, in my career, I've seen such a massive change in employment law coming all at once. Now, just a bit of background. At this moment in time, the courts are so overrun and so overburdened that they are not able to actually manage properly the cases that currently exist under the existing law. So much so that we are seeing preliminary hearings, and we're talking about hearings that are just to try and sort out the matters, being listed 2 years hence. And so sometimes tactically we will say, right, okay, financial institutional bank, we are going to take you to court, we're lodging, you just wait. And then the wind is totally taken out of our sails when it's like, oh, well, they've got 2 years before they need to do anything. That wasn't the point. The point was to apply pressure. So first of all, we do have a system that is overstretched and under-resourced. But alongside that, we also have changes that every HR manager and director are going to have to be so mindful of that will change things. I mean, the 2-year qualifying period. Every day of my career, I have spoken to people to say, it's horrible, it's nasty, it isn't discrimination, you can't do anything about it because you haven't got 2 years. Now, all those people who are deeply aggrieved now being able to bring a claim will massively increase not only the burdens of managing and properly dealing with issues and dismissals and misconduct in the workplace, but also it will just mean that companies will be exposed to a lot more claims. That's a simple fact. And so that's one of the things. Now, sexual harassment is I want to say hobby horse, but it sounds wrong. It's an area that I really, really believe in looking after for many levels, on many levels. And I think that one of the things that's absolutely delighted me is to see that the changes coming in in the area of sexual harassment. So I mean, one of the points is that that there always used to be a reactive requirement to take steps if a case arises, and now we have already in force an proactive obligation to make sure at all times we've got things in place, that we've taken reasonable steps to prevent sexual harassment. Now that could mean all manner of things. Have you, number one, got good policies? Have you trained staff? Are your staff aware of the policies? Do they understand the standards required of them? But now we're going to see, and this is a change, that's going to move from reasonable steps to all reasonable steps. Now, with reasonable steps, the presumption is there may be some weaknesses here and there, but that's okay. As long as we've got ABC, we don't need XYZ. Now we're going to need the full shebang. We're going to need everything done. So that's going to be a huge thing. And I'm really interested to see how that's going to work. But I like the idea of that, because I think that in the end, there is always an element of it not being a primary issue or requirement in the corporate world, because they've got to make money, they've got a business to run. So yeah, we'll do a tick box exercise, and I think now that tick box exercise will no longer work, which I think is going to be good, but not easy for the HR managers, not easy for the HR directors. There will be more guidance coming, hopefully very soon, given it's going to be in October, I believe. But the point is that there was always some element of protection that could be inferred, but now it's going to be overt. So that's going to be a huge and significant change. Removing the upper limit on unfair dismissal. I can't even tell you how many people I deal with for whom I have to say, that's a slam dunk. You have got a claim, but take the deal, because you can't get more than 120. And the real equation is this. So you got 120, 130, that's your upper limit, but that's not really the amount you can get at court. What really applies is that less legal fees, less factoring in the fact it might take 2 or 3 years, factoring in the fact, and this is the big one, if you're intelligent, employable, and the market is reasonable, you might get a job straight away. And that means you could go to court and win zilcho, nothing, but have a technical win. And so the law is effectively impotent. It doesn't have any proper legal effect for so many people. But one of the big factors is that if you're on a certain amount of pay, it doesn't serve you to go to court for any amount that's going to limit that pay. So for example, if you've got an upper limit at the employment tribunal for unfair dismissal of say 120, 130,000, then why would you go to court if your losses are so far in excess of that, and they're offering you a deal? And that's the key. Very often they offer you a deal. And so when you look at the whole matrix of factors, 99%, perhaps 95% for sure, will take the deal. So that's something that will change fundamentally if the upper limits are removed, and that will be very interesting to see. Now, one thing I would say that's going to be incredibly interesting is the non-disclosure, the NDA removal, and I've seen this creep in for the last 2 years. Anyway, in settlement agreements, and I think this is a phenomenal idea. In fact, as I mentioned before, I also write novels, and one of the things that I've always been quite keen on is the concept of how people can act horribly, and Weinstein is your perfect example. People can act horribly, then just pay other people off. And these gagging clauses, as we know from all of the Me Too scenarios, is that they can actually perpetuate a horrible and ugly problem, because super wealth or wealth means that people can just keep repeating their wrongdoing. And what I love about this is that it's not going to remove the possibility of a settlement, but it will remove the the right to gag someone potentially. As I said before, the fact that we do have a regime to protect employees is a good thing when you look at different countries and different areas. So as long as we're moving in the right direction, I don't have any complaints. Although, at all times, a government will have to balance the impact on employers trying to make money and keep people in jobs against the rights of employees who, and so that balancing act, I'm not sitting here saying it's an easy one, but it's a very real thing they have to assess. I'd say, in short, very short, sharp summary, proactivity is the absolute key. Reactivity is history. I don't think that any court these days will give any employer a nod for being reactive only, and that's reflected in the law, the requirement to take all reasonable steps, which is shortly going to be in. So there are many methods that can be used, and my hope is this whole approach flipping things on its head. So not just waiting for a problem and thinking, oh, we can do this, that, and the other in that particular case, but flipping everything on its head and saying, at all times, the company needs to have these things in place. So there are many things that can be done. I mean, one thing I would start with, which might be an odd thing to start, but I think it's important, is taking advice early. And that doesn't mean advice when there is an issue, but advice on what people can do. Because as lawyers in this field, there are so many things that we help implement, that we put into place. And I mean, let me just run through some. For example, risk assessments are absolutely key. I have seen situations, for example, where an employer came to me and there was an issue with an employee who had raised a grievance, because obviously we help at all stages. It's not just contentious. In fact, most of the time my processes are helping like a member of the board around the table, assisting with issues. And they would say that this person's raised a grievance, but we looked at the data and we've just noticed 6 people have left that department in the space of 6 months. And they discovered in that scenario that in fact there was a bad actor. There was someone very senior, very powerful, who was a horrendous bully, really, really nasty, and no one had reported it until this one person came forward. Why? They're all terrified for their jobs. They would rather quietly leave, find another job, and not have, caused a ruckus or caused issues, not risk their damage to their career by flagging it. And this is exactly what is wrong. I was so impressed with this company because they had formulated or come to the realization through the data analysis they did. And this was some while back, so it was quite switched on of them. But what we effectively did then was a risk assessment. So first of all, they took advice early. They didn't wait for this to turn into a tribunal claim. They just said, can we talk this through with you? So we did a risk assessment, and we realized that there were a lot of junior employees. There was very powerful senior people who basically never attended, or the company never really even did any training. And they felt they had absolute power. And so that was one of the problems, and it's also identified as one of the risk assessment factors that you have to look at. Other ones can include, how much impact people have with, the third parties. It can be the sexual mix, male, female, of the organization. We've all heard of the old boys culture and that sort of thing, which, by the way, is quite real in law firms too, dare I say. And so you do tend to find there might be a culture of banter. There may be the nature of the organization. So certain organizations just think it's okay. Some of the best case law we have is from car shops and mechanics, and where the boundaries are drawn at court because someone dared to say something absolutely horrendous in an environment where everyone spoke of in a relaxed way about sexual matters. But there was always a point at which something went too far and someone was prepared to bring a claim. So that sort of thing. Now, training, I can't emphasize enough, because in reality, it isn't by osmosis that people understand what's in their policies, and it isn't by sending an email round with a link that people suddenly become masterclass of understanding what the standards required of them. And so you do need to get some training, proper training in place. And as I say, I do physical training, but also digital training. So in a 10-minute slot, the key message in sexual harassment can be delivered. But a lot of companies want me to physically go there anyway. And we do half-day sessions, and that's all it takes. But the learning curve is so tremendous, and I always tell them that it's not just that that they've attended a session. That document with people's names written on it that they had attended a course is the document that we would show an employment tribunal. It's called evidence that we have not only done this and that, but we've also trained our staff. And I've done that many times. It's part of the bundle of documents. So that's something that can also be done. But I think also, and this is the key, and it isn't because I'm talking to Culture Shift, but I genuinely, honestly feel this, that fundamentally, a shift in culture will only happen by even more proactivity, by organizations like yourself coming in and actually taking steps to drill deeper and giving time to helping people change the culture in a situation where the company may not have that kind of resource, knowledge or time. The lawyers may not have all of the answers. And so it's very much a multifaceted approach that I think is needed. I mean, we do hear of organizations that are really wonderful to work at, and really interesting statistics have been found. I mean, I think there's a couple of really good books on this as well, like Blind Spot and The Difference, and various other ones that identify the findings. The research has been done. It isn't just an ethical issue. Of course it is ethical, but the reality is multiple studies have found that the bottom line, the performance of the company, is massively improved when issues of unfairness, of discrimination, of inequality are addressed. And even more interestingly, actually embracing diversity in all its different facets and ways increases the potential success of a corporation, because they've looked at problem solving. And when you get people that have come from different backgrounds, they have different ways of thinking, and their approaches to resolving problem, when they're given the opportunity equally with the main cohort, then problems are solved more effectively, more powerfully, and companies succeed better. That to me is the ultimate message, because what I find is if it's just a sort of a stick rather than a carrot, what tends to happen is people just do a tick box exercise, and they'll just say, oh, we've done this, we've done that, we've done the other, good, right, on to making money, onto the corporation. No, this is about, let's get the whole culture right, and getting onto the corporation means you will do better. And once that message is properly understood, I think corporations will embrace the idea of the purpose behind all of this new law wholeheartedly. I do know that there's one thing that often comes up, which I think is really interesting, is when you have an obligation to not discriminate, to be fair to women. Sometimes I've come across people who say that person is a racist, and this is a really subtle point, and I'm not sure how relevant it would be to this, but I think it's really interesting that sometimes it's not about what that person's personal views are, because you're not going to go in and dissect their brain and change. That would be nice. That would be my dream. And it's certainly something I thought about with books like Think Again and so on. But the reality is that it's almost irrelevant what they go home and feel and what they go home and believe. But in the workplace, they need to operate in a fair and equal, non-discriminatory manner, and they need to make sure that none of their policies, approaches, promotions, disciplinaries are biased, unfair, unreasonable, and so on. And so that's a subtle point. Of course, the ultimate aim with a culture shift is that people actually change at a fundamental level and understand their own unconscious biases, so they are therefore able to remove them. The most important thing is put it at the top of your agenda. There isn't a silver bullet. There isn't one thing that's going to fix everything, but what will fix everything is a multifaceted approach to this, taking account of everything, and at boardroom level, looking at it strategically, because if it's understood that, number one, you have risks and liabilities, number two, you have performance being affected and recruitment being affected, and number three, that actually there is an ethical underlying obligation too. So there's so many facets to this, but ultimately you don't want to be in breach of the law. You want the company to perform phenomenally, and the two are actually not the two come together beautifully. They're not mutually exclusive in any way. And so that when people understand that, the law may seem like a burden, a bind, but when they understand, put into place properly, will reduce risks and improve performance for the company overall. And importantly, because as you mentioned, the younger generation are not going to be fooled as the older generation were, it will ensure you attract the best talent. People watch this, they care. Every single junior that I deal with tells me exactly that it really matters to them. And so it's a win-win if you address this at the highest level and give it the focus and importance that it deserves.